Your Lordships will have on the bench a short note, which I've just handed in. That's relevant to issue 3, and I just invite you to put it to one side for the moment, but I'll come back to that when I get to issue 3. I was going to show your Lordships Declaration 2 made by the Court of Appeal, which is in the core volume, tab 1, and it's MS3500. Because I say that that's a complete answer to the point made by my learned friend in paragraphs 29 to 31 of his note of Friday. Declaration 2.
Which is the MS number?
Oh, I'm so sorry, 3500.
3500, thank you. And which paragraph are we looking at?
It's under it is declared that, it's paragraph 2, the relevant, it says confirming, but it should say conforming, interpretation of the ACT provisions is achieved by modifying the interpretation of section 231 so as to create a tax credit of relevant amount in respect of foreign dividends assessed by reference to the relevant FNR, etc. So what we are doing, and this is what Declaration 2 tells us, is creating a tax credit for the EU income. Now, there's no appeal against Declaration 2. It's in my learned friend's grounds of appeal, but the appeal was expressly not pursued. That's in a letter in September last year. And that's a complete answer in my submission to the point that's in the speaking note. So my learned friend is...
That's a complete answer. Just to look at the point to which the answer to the fact you can't achieve a... paragraph 21, is it?
So my learned friend says in paragraphs 29 and 30...
29 and 30.
This is page 14 of the note. It says, HMRC do not agree with the assertion at para 175 of the claimant's case as to the unlawfulness of the UK system. What we'd said was that you got credits under 231. Well, that's what Declaration 2 tells us that we get, and there's no appeal against Declaration 2. So the points that are made in 30 and 31 of the note are not open in the light of Declaration 2. There's no appeal against Declaration 2. Now, the second...
Where is the document which says there's no appeal?
That actually isn't in the bundle that your Lordships have. It's in a letter in September last year, and I can hand in copies if that would be useful.
So there's now no appeal against Declaration 2. Yeah, thank you.
The second point in the note, which is paragraphs 32 to 33, page 15, is also wrong. It's premised on the first contention in 29 to 31, but my learned friend is saying, well, the carryback didn't affect the amount of ACT that could lawfully have been charged. The short point is that my learned friend is misreading the relevant statutory provisions. I don't want to go to them. There's a very useful summary where the provisions are set out. It's FII High Court 2, para 209, which is Authorities 6, tab 56, and it's MS 1975. And those provisions make clear that, first of all, the ACT is charged. The effect of the carryback is that there is a repayment. So it's not that the original liability is somehow reduced. It's credit carried back, and that generates a repayment. So they were the 2 points I wanted to make on my learned friend's speaking note. I've set out why we say the Court of Appeal was wrong in our written case. And as the example in the written case on this issue shows, what the revenues approach is doing isn't actually prorating at all. This is the example at 181 MS 3487. What what actually is happening on the revenues approach is that the EU FII is being carried back first, and then later the UK domestic FII is carried back. And what my learned friend says is, well, when the UK FII was carried back, we repaid some of the unlawful tax. Now, that's not what actually happened. It doesn't fit the facts. It also doesn't fit how the UK system operated. So I say the judge was absolutely right in his conclusion at paragraph 42 of decision 2. The revenues approach wrongly eliminates credits that Prudential should have had, and the Court of Appeal was wrong to see issue 5B as a sort of subset of issue 5A, which is how they approached the matter. With your Lordship's permission, can I now turn, please, to issue 3?
Yes.
Under issue 3, the revenues contention, this is raised for the first time before this court, is that no claim arises where ACT that they say was initially levied lawfully is utilised against unlawful MCT. And the basis of that argument seems to be a contention that the revenue wasn't enriched in those circumstances. Now, my submission, that analysis is simply wrong. The starting point, which I don't understand to be in dispute, is that where Prudential has paid tax, which was unduly levied, it has a restitutionary claim, and Prudential also has a restitutionary claim where it has paid sums which relate directly to the unduly levied tax. That's FIECJ 1 para 205. We don't need to go to it. It's Authorities Volume 7, tab 70, and it's MS 2742. Now, I say we're within the first category. There has been a payment of tax unduly levied, failing which we're in the second, and I make 4 submissions.
Sorry, don't go too fast for me anyway.
I'm very sorry, my lord.
The categories we're talking about
So,
set out were...
The categories are in FIIECJ 1, paragraph 205. It's MS 2742. Paragraph 205, my lord.
Thank you.
That's not in the call.
And I don't understand there to be any dispute about that. So category 1 is payment of tax unduly levied. Category 2 is payment of a sum which relates directly to that unduly levied tax. And what I'd like to do in my oral submissions, I make 4 submissions, which is unpacking the 3 reasons, because actually reason 2 is best subdivided into 2. So my 3 reasons in the written case at 182 and following will become 4 submissions. And the 4 submissions are these. First of all, I say that even if it is right...
Sorry, I'm still not catching up with you. Which categories are we talking about now? Where are they set up? I mean, I just looked at paragraph 205.
205, and you're referring to this second category, the sums paid towards, in effect, undue tax.
Yes, exactly. It's tax unduly levied,
Yes.
and also amounts paid to that state or retained by it which relate directly to that tax. It's
And you say if lawful ACT
2742.
has been paid towards unlawful MCT,
Yes.
you fall within that second category.
So I'm going to make 4 submissions, essentially giving different reasons. Submission 1 is going to be that there's been an unlawful payment of tax.
He said even if it's right that...
Yes. So, but in terms of the architecture of this, my primary position is there has been a payment of unduly levied tax. If I'm wrong about that, this is what my Lord Carnwath called a Category 2 case, of an amount paid which relates directly to unduly levied tax. So,
I'm sorry, can I just be sure I'm following this? Are we talking about a situation where the the MCT is unlawful for some reason which doesn't affect the legality of the payment of ACT.
Well, that's one of the submissions I'm going to make, my lord, because what we'll see, and this is the second submission that I'm going to make, is that when the MCT is unlawful, as a matter of European law, the ACT itself is unlawful.
Because it's an advance.
Payment of an undue liability, my lord.
Yes, I mean, that is the economic effect of it, but it's not the way that it actually, it's not the way that the statute
Well, my lord,
poses it, treats it as a tax.
what I'm going to do, if I may, is dealing with submission 1 with the UK provisions. And my first submission is accepting for the sake of argument that the ACT is initially lawful in the language of issue 3. Where lawful ACT is set against unlawful MCT, when you look at the UK statutory provisions, there has nonetheless been a payment of tax which is unduly levied. That's submission 1. Secondly, second submission is that the concept of lawful ACT in this context is actually a misnomer, because when we look at the European authorities, when so-called lawful ACT is utilised against unlawful corporation tax, both the ACT and the MCT are unlawful, and the ECJ mandates that a repayment claim be available. That's submission 2.
The repayment claim of the unlawful MCT.
Well, there's a question about that I'll come
This
to.
is on the footing that they are effectively the same thing being paid at different stages.
Yes, exactly right, my lord. And there may be an
But I
interesting
mean, that would follow as a matter of logic anyway, wouldn't it? Simply because if the MCT is unlawful, then you're entitled to have it back, so to speak, in cash. You can't have it.
Yes, and if I'm right on
and
submission
have the benefit of the ACT as well.
1, and if I'm right on submission 1, I don't need submission 2.
Yes, I mean, your submission 1 is simply an appeal to basic logic. It's nothing to do with EU law, assuming them to be different.
I'm very sorry, I just didn't hear what your lordship said.
No, I think you did, because that's what I said earlier. Don't worry.
Oh, I see. I'm
Right,
very sorry.
Are you really, does it come to this, that the ACT is a payment to account of unlawfully charged tax?
So on submission 2, that's absolutely right. But I'm just trying to be more precise.
Where is this in the submission?
Well,
Might help me.
so
I get confused by category 1, category 2.
well, I'm very sorry.
Is it in your, where are we in your case?
So we're in the written case. Reason 1 equates to submission 1. Reason 2.
Sorry, reason, where do we get?
Page 3488, paragraph 185
Go
of
to the page,
the
isn't it?
case. You have a reason 1 and a reason 2.
Yeah, and I'm very sorry, my lord, if this has been
But
confusing.
reason 1 is that you are entitled to the benefit of the ACT. You're entitled to a repayment of the unlawful MCT.
Yes.
And you can't have one set to reduce the other because you're entitled to both of them.
Well, not quite, my lord, but can I just outline submissions 3 and 4 and then develop my points? In answer to my Lord Carnwath's question, reason 1 equates to submission 1. Reason 2 I've unpacked into submissions 2 and 3, and reason 3 is what I'm going to call submission 4 in the written case. And I'm sorry if that was an unwise thing to do.
Just to check something absolutely basic, the ACT and the MCT don't necessarily relate to the same income, do they?
Not necessarily, but my submission under submission 2 is that that's how they need to be regarded. The two are inextricably linked. The easiest thing, I suspect, is if I develop...
The ACT could relate to foreign investment income, and the MCT not, or vice versa.
Well, no, because what we're looking at is the use of lawfully charged ACT that was set against unlawful MCT. So the unlawful MCT here is unlawful because there weren't sufficient credits against the D5 charge.
Yes. But so you must be, I think, envisaging a situation where the ACT is being paid in respect of income which doesn't include foreign investment income.
That's a possibility, but then...
Well, if it did include it, there wouldn't have been the appropriate credit given on your arguments, and therefore there would be unlawful ACT.
Well, and that's why under submission 2, my lord, I quarrel with the very notion of lawful ACT. But perhaps if I can take the submissions in turn, rather than trying to do this in overview. The third submission, which is part of reason 2, is relying on the relates directly to the tax category. And the fourth submission, and this is if I'm wrong on all the others, is that Prudential would not have paid the ACT had the UK system operated lawfully.
Could you repeat 4, please?
So 4 equates to reason 3 in the case, and it's that Prudential would not have paid the ACT had the UK system operated lawfully.
Thank you.
So if I can start with submission 1, and this is developing really paragraphs 182 to 186 in the case. My submission is that properly analysed, when lawful ACT is utilised against an unlawful D5 liability, that the right way of looking at this is that there has been a payment of tax by Prudential and that tax was unduly levied. And I say that that follows from the statutory provisions dealing with ACT set-off. Could I ask your lordships, please, to go back to section 239 evicta. It's authorities 1, divider 8, and it's MS 4467. And 239 sub 1, which provides that ACT paid by company, read short, shall be set against its liability to corporation tax on any profits charged to corporation tax for that accounting period, and shall accordingly discharge a corresponding amount of that liability. So what we see is there's a statutory set-off of tax that's been paid, that's the ACT, against the MCT liability. There's no element of discretion or choice. It's not loss of opportunity. We're not talking about damages. Under the statute, the ACT, it's set against the MCT liability, and the effect of that is the MCT liability is discharged. And we're told, and I touched on this earlier, 239 sub 6, MS 4468, that the profits of a company charged a corporation tax for these purposes are the amounts of its profits for that period on which corporation tax falls finally to be borne. And then we also, so if we turn back to 238 sub 4, MS 4465, those profits are the amount of the profits after making all deductions and giving all reliefs, etc. So that the reliefs have been taken into account at an earlier stage. What's happening is the ACT is being used to pay the charge once the charge has been calculated. So it's the discharge of the actual mainstream corporation tax liability. And that corporation tax liability, it could be on any profits. It's not any particular MCT liability. Now, just staying with section 239, in 239 sub 2, we see the concept of setting against is repeated again in line 1, MS 4467. Carryback is dealt with in 239 sub 3, which we didn't look at yesterday. What one sees if one looks down to the bottom of the first paragraph is that where there's a carryback, there ends up being a repayment. And there can be a repayment, I say in parenthesis, if in the previous periods, the way in which the MCT liability was met was either by cash payment or indeed by set-off under 2391. 2394 is carry forward. And when there is carry forward in 239 sub 4, it's 2391 that has effect. The automatic set-off takes effect for those later accounting periods. So what we have is I say that the discharge and therefore the payment of a liability to MCT, it's Prudential's actual liability to pay MCT that's discharged by the setting against it of the ACT. Now, the revenues approach...
Sorry, this is still reason one, is it?
I'm still on reason one. Yes.
But you keep on referring to the liability, which is the terms of the statute, but by definition, since we're talking about an unlawful MCT, there isn't a liability.
Well,
so there's nothing to set it against.
Well, and I'm going to deal with that, my Lord.
Yes, but I don't see how the
directly.
statute applies at all to this situation.
Well, I make 2 points. First of all, we're looking at what happened at the time versus what should have happened.
But the statute must apply to the legal position as it is. I mean, if one just looked at what happened at the time, you paid ACT, why should you get it back? You only get it back because you look at the legal position as it should have been appreciated.
Well, so my first response is that the correct way of dealing with the claim is that at the time it was thought that the set-off operated, and that is the right comparison. But my second response, and this is where the note is of some importance that I've handed in, is that actually, when one looks at the facts of this case, if my learned friend is right, and if the point that my Lord Mans has just put to me, that the statute wouldn't have operated in relation to that unlawful liability,
right.
If that is right, the evidence that is before the court already shows that what would have happened under Section 2391 is that the ACT would have been set against other MCT liabilities. So the amount of cash tax that Prudential would have paid would automatically have been reduced. No element of choice, no element of discretion. The note comes out of a point my learned friend made yesterday. He said that there was very little...
So this isn't unjust enrichment by virtue of payment. It's by virtue of the revenues retention of other monies, is it really?
Well, I'm just going to explain that, my Lord. If I can just unpack the note first and just tell your Lordships what it shows. It comes out of the point my learned friend said yesterday, this was page 150, that there was very little capacity to use ACT in Prudential. He said you couldn't use it elsewhere was the implication. And so we've done some work looking at the computations that were available at trial and which were then agreed to value the claim. And what that exercise shows, and this is in paragraph 3, that in 1992 through to 1998, substantially more cash tax was paid than any amount of lawful ACT that was utilised against unlawful D5 tax. That's what the tables, which are reproduced from material that's already before the court, show. 1991, there's no cash tax, but we're talking about £15,000. And
This is this table, this is the paper we've just seen.
Yes, indeed.
And we haven't looked at yet.
Not yet. I'm explaining, Lord, what it shows. But this is describing data that's been before the court throughout.
Yes, but not before us.
Not before you.
Or indeed before Mr. Hewitt. So,
No, but it responds to a point he was making yesterday. 1991, no cash tax, but it's only £15,000, and you deal with it under carryback anyway. And the end of paragraph 3 of the note identifies the point in terms of the revenues enrichment. On this hypothesis, the revenue got additional tax from Prudential to which it was not entitled. And the reason for that is that even if it is right, and my first response to the question my Lord Mans put to me is wrong, that 2391 didn't operate in relation to an unlawful MCT liability, 2391 absolutely did operate automatically in relation to the other MCT liabilities.
Well, presumably then Prudential overpaid the other liabilities. Why can't that be corrected?
It can't. Well, no, it can't be corrected.
Well, I mean, you say it operated automatically. That's part of the reality which ought to be realised on your scenario. I mean, is there some limitation problem or what?
Well, no, my Lord, there's no limitation problem because the MCT liability payment date is the same. The overpayment happens at the same time in the same accounting period.
I see. So effectively, you're saying we correct that overpayment.
surely that could be corrected under the statute.
Well, certainly 1990 to 93 are closed.
But that's what I was asking. I mean, by my reference to limitation.
Yes.
But
You can't bring in restitution to overcome problems with the statutory.
Well, but this is just another way in which the tax has been
no, but if it's a
overpaid
statutory
on this.
scheme, then we're not here to offer remedies which parallel the statutory scheme, I think is my Lord's point, isn't it?
As far
I don't so far as I understand this.
Yes.
It's not-
As far as I understand it, what you're saying is that the ACT was legally due. It was you made distributions. ACT was payable on the distributions under the Act.
Correct, my Lord, yes, on this hypothesis, and it's lawful.
So the only problem, in inverted commas, is that it wasn't in fact set off, it wasn't in law set off against the MCT that you thought it was, because there wasn't any such MCT liability. And so either it was set off against a later MCT liability, or if it hasn't been set off at all, then it's still available to be set off.
Well, and what I'm saying, I'm doing this in two stages. So my first response is that we don't even get into this, because what we need to look at is the position on the basis that the statute operated. I'm currently addressing your Lordship's however, on the basis that it didn't.
Yes, well, I think that's the helpful way.
Yes.
Unless you want to get back on the first point.
And on that hypothesis, what I'm saying is that in the scenario we're looking at, there is an unlawful liability, namely the liability to MCT, and if the point is correct that 2391 didn't operate in relation to the unlawful MCT liability, there is clearly an overpayment of cash tax because other liabilities were paid in cash when they should not have been.
Yes, well,
and there is enrichment and there is mistake.
We're saying that, I mean, they were in fact paid, but the legal position should have been different, and I think the problem is whether that isn't simply a matter of the way in your accounts are presented, and whether we can reopen that now.
Well, but the way this case has been presented, my Lord, and this is common ground, is that we're dealing with all the issues of principle. This is paragraph 262 in the judge's judgment. It is MS 3689. So we're looking at issues of principle. Once we've dealt with the issues of principle, there's then a debate as to which court one has to go to work those through. And what one sees in 262 is that where possible, this happens through the statutory machinery. 262. So there's no...
3689, you say?
Yes, MS 3689. So it's not an answer, in my respectful submission, to say, well, this should be done by correcting returns or something like that. What we're interested in is the correct position.
Well, it may be important, though, whether this is a restitutionary claim or not.
Well, and my Lord, my response to that is that it is, because if one looks at what happened here, 2391 operates automatically on a return going in which shows ACT and which shows D5. And where we are is that because of the particulars that were put on the return, what has happened is Prudential has used the ACT to pay an unlawful MCT liability, or what it's done is wrongly triggered or sought to trigger the 2391 set-off in relation to an unlawful liability. There's no difficulty in my submission in analysing this in terms of an unjust enrichment claim,
I mean, the point,
in terms of the enrichment of the revenue.
the point surely is simply that the ACT was a valuable commodity in the sense that if it hadn't been set off against an unlawful liability, it could have been set off against a lawful one. Is that the point?
On this submission, yes, that's right.
So, in other words, you're entitled to the benefit of the ACT, and you're also entitled to the repayment of the unlawfully paid MCT. They are not the same thing in different guises,
Yes, I'm not quite sure I
They
follow
are
you.
both rights which you are entitled to have.
Well, quite so,
If
my
you
lord.
envisage the remedy, the second after you paid the MCT liability arose, you could simply have that wiped out, thereby releasing the ACT for use for some other useful, valuable purpose.
And critically, the use of the ACT would have happened automatically, not with any degree of choice, claim, election,
Yes, but
damages.
I
It's
don't
not,
think
it's
the
not damages, it's not
automaticity
correcting
makes any
returns.
difference to the analysis. Essentially, you're entitled to both the reversal of the unlawful MCT and the benefit of the ACT you've actually paid.
I'm not sure I follow your lordship's point on being entitled to the
Have I-
benefit of the ACT
I
that
misunderstood
I've
it.
paid. Because what I'm saying ultimately is that the ACT
You're actually
meant...
become entitled to rather than paid. Sorry, yes.
Does it come to this, that on your argument you've effectively the perfectly lawfully charged ACT has been used to, in reality, it discharged a different, as a matter of law, it's discharged an actual MCT liability, which isn't the one you thought it had discharged.
Well, and the result of that comes from a mistake about the
Yeah.
lawfulness of the UK system. That's why we're into enrichment of the revenue and a mistake-based claim.
So
So it's the other MCT liability which is unlawfully.
That would be right, yeah. So we thought we discharged a particular liability. That liability, as it happens, was unlawful.
Yeah.
And there was another liability which we paid, but that liability actually is unlawful because on your lordship's hypothesis, 2391 had said actually you don't need to pay that in cash because we're setting the ACT against it.
Right.
But at the end of the day, you should be able to map the ACT payments you've made against the lawful MCT liabilities, and at the end of the day, draw a line and see what the balance is.
Well, my lord, that's what the note does.
But at the end of all that, what I'm still worried about is whether the complaint isn't you just paid too much tax and you should be entitled to it back through the statutory machinery.
Well, and that's why I showed you lordship paragraph 262, because what I'm saying is that on any...
Yeah, well, I mean, 262 is not binding on us or anything. It's just simply a stage in a very long process of litigation.
Well, my lord, it's
I'm
not...
concerned with the statutory position. If we got a restitutionary claim, we've got to be satisfied that it's not covering something which is already covered by the statutory machinery.
Well, and my respectful response to that is that what we have on any view is a payment of tax which was made by mistake, and there is no suggestion that the autologic principle ousts those claims. My lord, I'm conscious of the time. Can I move on to submission 2?
But are we, sorry, this document we've been given, when are we going to look at that?
Well, I've summarised what it says, my lord. The point of it is to show that in each year, with the exception of 1991...
There were other things against which this could and should have been...
Well, my lord, more than that, was utilised if the hypothesis that your lordship put to me is right.
Yes.
Other than 1991, and there it's carried back and it's £15,000.
Yeah.
And that's what the data already available shows. So, my lord, submission 2, this is the written case, paras 187 to 195. And what I say is that actually what the Court of Justice's jurisprudence shows is that this notion of lawful ACT, it's a misnomer. The reality, using the language of issue 3, where you've got lawful ACT utilised against unlawful MCT, all of the tax is unlawful. And I base that on 3 key propositions which are in the written case in 187 through to 195. The first is that the ECJ has consistently recognised that ACT is nothing more than a payment of corporation tax made in advance. That's proposition 1. And that's 187 in the written case where the references are given, and that, as we've seen, reflects the way in which Section 239 operated. Proposition 2 is that ACT can only lawfully be charged where the ACT is itself a prepayment of a lawful MCT charge, and that's in the written case, paragraph 188, and it's FI ECJ 2, Paris 72.
Yeah, that's a different reference. Oh, I see. No, the next one is his. I see.
Yes, it's the quotation in 72 makes that good. Because what we find is that the obligation to pay MCT, that was justified only to the extent that there was a lawful MCT charge. So to the extent that the ACT isn't functioning as a prepayment of a lawful MCT liability, the MCT is unduly levied. That's
I
proposition.
don't want to go over the same material time and again, but on the discussion we previously had, it always will be.
I'm sorry, Miller, what
The
always
ACT
will be?
will always be a prepayment of a lawful MCT, provided at some stage or other there is MCT available against which it can lawfully be set off. I mean, if for example, you pay the ACT in year one, and the supposed MCT in year one is unlawful, then as a matter of law, you're not setting the ACT against that. But if in year two there's lawful MCT, then the ACT operates as a prepayment of the lawful MCT in year two.
No, but the ECJ is saying much more than that. The ECJ is saying that to the extent that there is not a lawful MCT liability, the levying of the ACT is unlawful. I get that from 72 in FI ECJ 2. And the third proposition...
So you're saying as a matter of law, unless there is lawful MCT charged in a given quarter, then it's unlawful to charge ACT in that quarter. You say that's EU law?
Yes, that's what the ECJ says in terms...
It doesn't seem to spring out of the page.
No, I think, well, it doesn't say in that quarter. All the ECJ is saying is that the hypothesis on which ACT is lawful is that at some point there is going to be lawful MCT payment.
Except even that is slightly odd, isn't it?
Paid or credited, I suppose.
Because you can have a situation in which ACT is never recoverable because there's never sufficient future MCT or carryback available for that purpose.
Because it was never utilised.
Yes, and you don't, and the result then is, except in certain cases like carryback, you don't, as I understand it, get the ACT back. You just lose it.
Well, but Mano, that's a different point to this, because there wouldn't be any question of the unlawful MCT.
Well, I know,
charge.
but the suggestion that there's no legal right to charge ACT, save insofar as there is an available liability to credit it against. I don't see on what juridical basis EU law could make that point.
Yeah. Well, but Mano, the point that
that's not a matter of EU law.
Well, Mano, the point that the ECJ is making, perhaps I should show this to your Lordship in the original, goes to the extent to which it is lawful to charge the ACT. FI ECJ 2, it's in Authorities Aid, and it's tab 73. And MS 2811 is the proposition that the charge is justified.
Next paragraph.
And so it's paragraph 72, MS 2811. ACT can only lawfully be charged where it is itself a prepayment of a lawful MCT charge.
So this is 2811, paragraph 72.
Paragraph 72.
This purports to be a description of English law.
No, what the court is doing is it is telling us what, as a matter of union law, is permissible. Because what the court goes on to do...
On that footing, let's suppose there's no question of illegality at all, there's just no MCT liability against which to set the ACT.
Well, then I'm not within paragraph 72, my lord.
Well,
Because we're looking at income to which...
because I misunderstood your submission. As I understood it, you were telling us that EU law says that you cannot lawfully levy ACT except when there is an available liability to set it off against.
Well, that's not...
That would be completely inconsistent with English law in a respect with which EU law is not concerned.
Well, with respect, your lordship is looking at the matter too broadly. You first of all have to find EU law rights engaged, and that would be on the distribution by an EU, say, company to a UK company. So necessarily you would have D5 tax on that distribution.
There is an unlawful MCT.
Yes, and that's the hypothesis that we're looking
Well, in
at
that case,
under...
yes, it is saying something a lot less remarkable than what you appeared to be saying in paragraph 188.
Well, I'm quoting it in 188, my lord. That's what it says in 72.
In 72, well, 72 seems to be dealing with an entirely different point.
Yes.
I thought it was dealing with the basic proposition that in respect of foreign source dividends, you have to give some sort of credit which eliminates ACT, except to the extent that you need to take account of a difference between the lower nominal rate of tax abroad and the nominal rate of tax domestically.
Well, that's what they do in 72, but what they then do, and this is why I put it in terms of in three propositions, is that in 87, this is dealing with question 3, they say that where the ACT, this is 2813, where the ACT has been unduly levied,
83, right?
and we're on paragraph 87, 2813,
Yes, 87, sorry.
insofar as it exceeds the additional corporation tax which the member state in question was entitled to levy in order to make up for the lower nominal rate of tax. That's building on the more general point they make in 72. The taxpayer may bring an action for repayment.
Well, so that just means you get back unlawfully
Levied ACT.
ACT, and extracted ACT.
Well, but what I draw from that, I'm very happy if that's right. Issue 3 doesn't actually arise at all in the terms in which it's being put. If we end up on that scenario with an action to recover the ACT that was paid, that'll do from my point of view. Because what this is demonstrating is that when you've got ACT, if it's acting as a prepayment of an excessive liability to MCT, the ACT is itself excessive and is levied unlawfully.
And this seems to me to be actually another way of putting your reason 1.
Well, it may be another way of putting it more in European terms. What I was trying to do was separate domestic law and European law. And I do say that I've got the full weight of FI-CJ2 on my side when it comes to submission 2. And it's not just that the ECJ is conceptualising ACT as an advance payment of corporation tax. Paragraph 87 is putting this explicitly in terms of remedies.
Yes, but the trouble is it's talking in terms of has been compelled to pay, and the whole argument against you is that if you, under a mistake, treat valid ACT as set against invalid MCT, you haven't been compelled to pay anything, you haven't paid anything either. It's a nullity, the ACT survives.
Well, no, my lord,
and
that's...
you say it gets set against something else.
Well, that's my submission 1. My submission 2 is that the initial levying was unlawful. We were
Yes.
compelled to pay the ACT.
That
If it is a payment.
That was because you distributed profits.
Yes,
And that's not, there's nothing unlawful under EU law in that.
well, my lord, save to the extent that that charge is exceeding the valid MCT liability. So that's submission 2, and that
Right.
focuses on the
Yes,
ACT itself. I'm conscious of the time.
How are you doing?
I'm hoping to be not more than 5 more minutes,
Right,
which I
right.
hope will give Mr. Beasley enough time.
We'll
But
try and restrain ourselves, but it's difficult.
Submission 3 I can put very shortly. This is in the written case at para 191.
Yep. This is submission 3 at one.
This is submission 3.
Okay.
And that is that on any view, the payment of the ACT relates directly to the unduly levied MCT. So that's category 2 in FIICJ 1, para 205.
Right.
Because we've seen the ACT is a payment in advance of the MCT liability. The UK statutory provisions show that what was thought to have happened at the time is that the ACT is set against and discharges the MCT liability. Taxpayer had no say in the matter. And there couldn't, in my submission, be a more direct link than that. So submission 3 is very short, but there has been no effective answer to it. And
Would you mind very much if it could be called submission 3(2)B?
I wouldn't mind at all.
But it's just because we're going to be looking at a transcript.
Of course.
I'm going to be trying to relate this to your
Of course,
submissions. And because your reason 3 has become your submission 4.
it has. And
Right, let's call them submission
Here we have 2A.
I'm very happy with
2B,
1, 2A, 2B and 3.
Sorry to be
No,
difficult.
not at all.
And 2B starts at 191.
Right,
I don't.
carry on.
2B is 191. And it's a short point, but there's been no effective answer to it in my submission. Submission 4 is that Prudential wouldn't have paid the ACT sorry, submission 3, and reason 3 is that Prudential would not have paid the ACT in any event. This is 196 and 197 of the written case. And quite simply, the claimant here is Prudential Assurance Company Limited, PAC, and PAC had a parent, Prudential PLC. And ACT, in the context of a case like this, would be paid at the level of the subsidiary, so the PAC level, so as to anticipate the corporation tax which PAC itself is due to pay. The reason for that is that if you use the ACT otherwise at the PAC level, you may not be able to use it at all. You can see that there's a description, FII Chancery 1, FI High Court 1, paragraph 32. So FI High Court 1, paragraph 34, and its authorities, volume 5, tab 53, and it's MS 1579. The reason is that you could only surrender ACTs to subsidiaries, so you needed to have the ACT higher up in the structure. Where we are on this submission is that the reality was that a substantial part of PAC's corporation tax charge in reality didn't exist. And we say that in those circumstances, what would have happened is PAC would have distributed more of its profits under its group income election. It would have been foolish to do anything else. Now, your Lordship may say to me, that sounds like a damages claim. Well, I say in response that the making of a group income election, that would simply have been a matter of course, just as the judge found in relation to a slightly different election, section 4386 election, which is in para 149 of his main judgment. That's MS 3644. So my submission 3 is that this is actually just like a case like Deutsche Morgan Grenfell, where had it not been for the unlawfulness, dividends would have been paid under a group income election. And so I say that the revenues analysis, which is founded on the proposition that there's no enrichment, that's misconceived. Because I say, first of all, the revenue are wrong to say that 239 didn't operate, but that even if you ignore the set-off under 239, ACT would have been applied elsewhere. That's reason 1. And then reason 2A, I rely on what the ECJ has said in FIECJ 2, which I say shows that the initial levying of the ACT was unlawful. Or 2B, the ACT relates directly to the unlawful MCT charge, as the Court of Appeal found in 2010. And then I rely on my reason 3, if I'm wrong.
Wouldn't this
about all
simply
of that.
put Prudential PLC in the same position in relation to reasons 1 and 2 as the PAC has to argue, i.e. the effect of group election would be that the 2 would be treated as 1 and the income would be received, the dividend would be received by Pru, which would, as regards claiming any rights under EU law, presumably stand in the same position as PAC does now. So does this add anything to reasons 1 and 2?
Well, it does, because PAC would have been, Prudential PLC would have been able to surrender the ACT back down again. So that there is that difference.
When we say surrender it back down to whom?
Well, to other subsidiaries.
Yes, I see.
So
Yeah.
on reasons 1 and 2b, the unjust enrichment, the enrichment of the revenue comes with the discharge of the unlawful tax. And then on 2a and 3, the unjust enrichment of the revenues when it received ACT which shouldn't have been paid. And just for completeness, there's never been any suggestion that if Prudential is right on enrichment, that there was a mistake, and that mistake's never been challenged, that the revenues case is all put in terms of enrichment. Now, just for completeness, there is actually some doubt that the revenue actually secured permission to appeal to the Court of Appeal at all on what's now issue 3. There's a declaration dealing with what has become issue 3, which is declaration 8 capital A Roman 6, which is MS 3578. What one finds is when one looks at the judge's order,
Which declaration, which number?
it's MS
Declaration 8.
It's 8 capital A Roman 6.
So 3578. Yes.
Yep. And it's starting lawful ACT, which was utilised. That's the declaration that's given rise to issue 3 here. The judge's order deals with permission to appeal at paragraph 9, which is at the bottom of 3581. And what you see is there's actually no permission in relation to that declaration. Now, the revenue did include as a ground in their grounds of appeal to the Court of Appeals, not in the bundle that your lordships have, but it's ground 7, an appeal on that declaration, but never asked for nor were given permission to appeal. And it's not on the list of issues.
Want to go to the Court of Appeal?
Well, it just wasn't. It was never. It was just never dealt with. It looks as if it may have been assumed that they had permission on that point. I just
So
mentioned.
where is the no permission to appeal on page 3581?
Well, so the judge gives permission to appeal on a number of matters in paragraph 9, and declaration 8A Roman 6 is not one of them. That's the short point I'm making.
Okay.
And it's not in the list of issues for the Court of Appeal, which is Appendix Part 2, Divider 18, MS 3893. So I just, the point was aired in the oral argument yesterday, and so I just, that is...
Are you saying they don't have leave, or that they weren't given leave?
But the Court of Appeal dealt with this.
Well, no.
They didn't deal with it at all.
Okay.
Well, no, they simply noted that they were bound by what had been held in FI Court of Appeal. I think it's paragraph 120.
So no one took an objection that this.
Paragraph 100 what?
I think it's 124 in the Court of Appeal, my lord.
But no one took any objection, my lord's point.
Well, no one took any...
Objection to it being raised.
Well, it wasn't raised, my lord, that's the point.
I see.
It wasn't raised in the Court of Appeal. There's
I thought you said it was raised, but they said they were.
No, my lord, what I'm saying is the Court of Appeal simply observed that they were banned. They weren't dealing with this point. This was in the context of issue 5A. Perhaps I better show your lordship the point. This isn't dealing with what's now issue 3. It's MS 3540. It was paragraph 124. And the court is simply noting the position. There was no argument on any of this in the Court of Appeal.
3540, wait a minute.
Yes. So what I'm saying is that...
124, apparently. Oh, I see. Well, they are treating it before them, aren't they? Aren't they sort of saying...
They're dealing with it and saying they're bound to reject it.
Yeah.
Yes, but so the point I'm making is that one can't actually identify how that point got in front of the Court of Appeal.
No, but it's quite often points come up and are not no technical point is made on leave, because there's no point in doing that.
My Lord, what
I mean, the question is, are you formally saying that they have no right to raise it or not? Because if you are, then we need to be clear the basis. If you're all saying, well, this is a throwaway point, well, we can leave it there.
No, well, I accept that there was an assumption that the revenue were reserving their position.
Yeah.
I'm simply because this does go to your lordship's jurisdiction.
That's why they had
So I'm
an
noting.
application on foot for permission.
Yeah.
Yes, my Lord, but what I'm saying is that if one looks at the documents, it is not at all obvious that the revenue
No, it
actually
is.
had permission to
Very
go to the
obvious.
Court of Appeal.
Very few things are obvious in these papers.
Well,
We have to sort of dig
What
around.
I do, however, emphasise is that there is something very unsatisfactory about this issue coming in at this stage.
Well, there seems to be quite a lot unsatisfactory procedurally in this
that may-
case.
that-
I
that-
don't think I've ever seen a case where the issues have to be plucked out of the air,
Well,
effectively,
no,
rather
but
than,
you
clearly
see,
defined.
but your lordship sees, for example, the point that was made yesterday about ACT capacity, which we've sought to address in the note. And what I do say is that these points, they should have been run out by the revenue at trial, because
Where we were shown something which showed how much was at stake on point issue 3. It's quite a big issue.
it is, my lord, yes.
Where did we see how much was at stake on issue 3?
That's in the statement of facts and issues, and one can see it from paragraph 7. It's MS 3329. But my lord, the fact is the revenue did not seek to run the point at trial. They didn't argue it out. They've sought to bring it in now, and there are problems with that course being taken.
Sorry, I thought they were showing us there wasn't much at stake. I thought there was another table which showed us that there was a lot at stake.
Well, it's the differences show you the effect on the claim of the rulings on issue 3. That's what the table in paragraph 7 does.
It says issue 2. But
Mine says issue 3, my lord. In MS 3329,
I think it's depending on the outcomes.
sorry, MS3.
3329, my lord. It's paragraph 7. That's the table your lordship has in mind.
Now, issue 3 does seem to be the bottom line in each table, and there's quite a big difference.
Yes, there is, my lord. But that only, in my submission, reinforces the unsatisfactory nature of this being brought in by the appellants now.
Well, this is a document which seems to suggest that this is before us. I don't know, wait a minute, should permission be granted?
Well, yes, your lordships first have to deal with the question of permission.
Yes, I mean, you're not disputing that, no one's disputing that there has to be permission to appeal to this court. Your attack is whether the revenue is in a position to seek permission.
Quite so, my lord.
Yes, but people have prepared for this hearing, as we see from 3329, on the basis that this may well be before us.
That's right, my lord.
And therefore, no one's prejudiced by it so being.
Very sorry, my lord.
And that you're not asserting prejudice by virtue of the case having come to
Well,
us.
I've made the submissions I've made.
Yeah. Thank you.
Right. Probably your 5 minutes.
Yes, as has expanded. Can I hand over to Mr. Beasley, my lord?
Can I just give your lordships the reference to the Commission's written observations to FIECJ2. It's in Appendix Part 2, the core bundle, tab 31, paragraphs 21 to 35, and the MS references are 4108 to 4113.
Speak up. I've got 21 to 34, and
Yeah,
what?
21 to 35, MS 4108 to 4113.
And this is Commission's observations on what?
This is Commission's observations, their suggestion that the FNR should be taken as a solution to the problem.
Yes,
It was their own version of it. It's not quite the version which the ECJ finally adopted, but that was the first mention of FNR. That's probably the origin of the thinking.
Right. Yes, Mr.
Lords,
Beasley.
I've become the truncated C movie. Lord, I'm going to address issue 2. I can do it very quickly, I hope, because we've set it out in considerable detail in our case at paragraph 97 and following at 3447, and the introduction at paragraphs 4 and 6 to 10. There were some points I wanted to elaborate, one of which follows on from the discussion we've just had, is that we do object and object on principled grounds, objected to two matters that are relied on by the revenue in this appeal as regards compound interest, and that's in particular their attempts to argue no actual burden, no actual benefit, and the burden of proof being on the claimant, and that the claimant has not satisfied that, and for category C, that there's no transfer of value. Lords, before I show you the underlying documents, the orders and so on, I thought it'd be helpful if I just very quickly gave you the principles which I would like to extract from the documents when I show you. So the first is there was only ever restricted permission to appeal to the Court of Appeal on claims to compound interest for categories B and C being impermissible because of Section 35A. That's the only ground on which there's been permission to appeal.
Only ground
is
of permission to appeal to Court of Appeal?
To the Court of Appeal, yes, my lord.
Was inconsistency with?
Inconsistence with Section 35A.
In the case of categories B and C.
In case of categories B and C. Lord, there's no...
Can we just see that? Where do you
yes,
find
my lord. That's in core volume. It's the order you've seen twice already. It's at tab 6, the order of Mr. Justice Henderson of 28th of January 2014. Right. Lord, if I might also show a couple of other matters as I go through so as not to have to pick it up again. You've already seen this is the order after the trial. And Lord, if one looks, and you were shown at the top of 3573, this is the resumed trial on all issues save only for quantification of the amount of damages and confirmation. And I'll just mention at the second and upon third on page 3573, the defendants confirming that issue 713 is confined to the defence of change of position, no reliance on other defences, particularly of passing off or fiscal chaos, which had been referred to. And then comes the declarations, stop at 3574, and the particular one that I am looking for is at 3578. Your Lordship will see 10, compound interest computed on the conventional government basis payable in all respect of all claims which are upheld, namely overpaid corporation tax, unutilised ACT, and ACT utilised against MCT. And then at the bottom of the page, and very importantly, you see it as order number 1. It is not open to the defendants, having adduced no evidence, to rely on the defence of change of position in the present proceedings. Your Lordship may have seen in the original judgment of Mr. Justice Henderson that there was an attempt to run change of position as a theoretical advisory application with no evidence. And that was rejected as being wholly inappropriate. But over the page at the top, and very importantly, given what is being argued to you now, 2, it is not open to the defendants to adduce evidence after trial to show that the government was not enriched by receipt of the monies in question. So Mr. Justice Henderson has specifically, as the trial judge, stamped on an attempt after trial to introduce fresh evidence about no enrichment, and yet they're trying to run a no enrichment argument before you now. Then at 4, at the bottom of the page, also important, the amounts of restitution to be calculated on a compound interest basis computed on the conventional government rate from and so on. Then at 6, I think Mr. Aronson has already referred those to, but 7A is important. The following directions apply for the calculation of quantum and payment. The terms upon which compound interest on the conventional government basis should be calculated as agreed between the parties are the rates set out in Schedule 2 of this order, compounded monthly. So following the trial, you've got an agreement between the parties as to what the conventional government rates are and that those are to be applied. Now, coming then over the page 3581 of the manuscript, so at paragraph 9, subject to paragraph 10, the defendants are granted permission to appeal the following declarations and corresponding paragraphs of the order. And the one I referred to at the beginning is F on that page. declaration, compound interest, limited to the argument that the claimant's claim for unutilised ACT or paid corporation tax and the claim in respect of the ACT post-utilisation fall within Section 35A of the Senior Courts Act and therefore only simple interest is due. They don't have permission to, and they were prevented from adducing evidence too late on unjust enrichment, and they have no permission to argue on any other topic. And there's a good reason for that, which I would like also to show you, if I may, what the defendant's skeleton for the trial was, showing the position they took on this matter, because it's entirely inconsistent with what they are now saying. So the defendant's skeleton is in Respondent's Volume Bundle B, starts at page 4274.
I mean, does this matter if they're precluded from running it by a court order? Does this help?
Well, my lord, I was only going to show you that their position at the trial was exactly the contrary of what they're now saying. They were saying that the burden that they, perhaps the simplest one, and it only helps in this sense, 93, this defendant's skeleton at page 4311 MS.
4311, yes.
Paragraph 93. Prudential, this is the revenue. Prudential is in principle entitled to an award of compound interest in respect of the government's enrichment in the period for the time it paid ACT prematurely to the time that ACT was set off. Such compound interest should prima facie be calculated at conventional rates applicable to government borrowing for the relevant period in accordance with the decision in Sempra. It is, however, open to HMRC to adduce evidence to show the government was not enriched by receipt of the monies in question. And yet yesterday you were being addressed on the basis that the burden was on the claimants, that they hadn't satisfied it, and that was a basis of appeal. And your lordships will see that the judge's order, which I showed you about being barred from producing evidence about unjust enrichment after the event, was triggered by this assertion that it's open to HMRC to adduce evidence to show it was not enriched by the monies in question. Lord, then the arguments on the other two categories are...
I mean, you don't quarrel with that as long as they've done it at trial, presumably.
Well, Lord, if they, yes, but the position is you've got the, I think as your lordship said yesterday, you've got the prima facie position from Sempra, conventional government borrowing. The rates are agreed.
Yeah.
For most defendants, and I wouldn't quarrel with that, they can try to prove that in some way they, in their objective circumstances, should be treated differently, which is sometimes called...
Quite difficult for the government, you say?
Yeah. Government is different for at least two reasons, and this we would also have wished to argue if this was actually before you. One is that it should not be permitted as a matter of EU law to say no interest is payable. The only defence that's allowed is passing on under EU law, under Lady and Kidd. But even ignoring that, what you get from Hurst and the other Court of Justice cases is that a denial of interest at all is not permissible under EU law. It may be a question of whether it should be compound interest or not, but you couldn't say on no enrichment that there was no interest at all to be paid for this sort of unlawful tax levy.
Right.
Now,
so what, assuming, I mean, this is 94 and 95 raise the Section 35A point.
yes.
What is it that the declaration actually, in practice, shuts them out from arguing? Because fall within Section 35A and therefore only simple interest is due might open the way to quite a wide range of arguments about things.
But Lord, that, in my respectful submission, is why I showed you what was argued at the trial and what you see from the judge. The argument wasn't about reversal of the burden of proof. It wasn't about any evidence to detract from or restrict the...
No, I can see that.
Nor transfer of value was not argued either.
Well, I was going to say transfer of value might be a reason why it falls, if anywhere, within Section 35A.
Yes.
If there's no unjust enrichment, then you fall back. So doesn't it open quite an argument?
Yeah, they might not be blamed for not anticipating what this court might say subsequently in investment trust companies.
Right.
Lord, I think as far as no benefit is concerned, that must, with respectful submission, be shut out by what happened at the trial, what the judge ordered, and absence of permission. Because later on, not only was there an attempt to raise this with the Court of Appeal, but the Court of Appeal also refused permission to appeal to it on enrichment, albeit that that was an enrichment put in a different way. And this is at the order directly appealed from to this court, which starts at MS 3499. So that, of course, that was the judge's restriction, but you don't find anything from the Court of Appeal permitting either enrichment generally to be argued or transfer of value, although I do accept transfer of value could be in a slightly different category, because that could be more nuanced to say what Section 35A buffers.
Yes, but,
So
what are we looking at in the Court of Appeal
on
order?
page MS 3500,
Yeah.
we've shown this already, under order paragraph 1, permission to appeal is refused in respect of these issues, and the 1B and 15, shareholder credits, no enrichment. Now, that was actually a slightly different argument. The argument was that it shows that an attempt was made by HMRC to appeal some form of no enrichment, but it wasn't the one that they would like to say now about no actual benefit, and it was rejected. It was, in short, shareholder credits was the argument that because there were ultimately shareholder credits in respect of, or linked in some way to ACT, that was a change of position, but that was not permitted.
That's a different ballgame.
Different ballgame, and it will come up in FIR. So, Lord, you don't find, and then you find the 14 shareholder credits change of position.
Yeah.
Also.
But there's nothing specific here about...
There was no application was made for a wide, no application was made to say, we're sorry, we argued below that it was prima facie conventional and the burden was on us, HMRC, and that has to be the subject of appeal. That was never suggested.
No application to expand the judge's limited position.
No, nor to reverse the position below, namely that if they were going to displace the conventional government borrowing rate, the burden was on them to do so. That was their case below. So they'd have had to have permission as well to argue a point not only not taken below, but contrary to the case taken below. And that was permission was refused by the Court of Appeal. And I don't need to tell your Lordship, as if permission has never been given to get to the Court of Appeal, there's no power for this court to allow an appeal. You can't appeal against a refusal.
I don't think you need to tell us that.
I didn't think I did. Now, so that, but if I could then address quickly, if I had to address benefit, I've already mentioned the EU point, there's another point. Both of these are in our skeleton argument below to the Court of Appeal, but I don't need to rely on them. We put them in case this was argued and it was refused permission and rejected, but we put them in, and that is, one, it's contrary to EU law to have no actual benefit, and secondly, it's contrary to English law domestic principles. In FII, we've argued this, and it will, assuming permission is granted, come to this court, that change of position should be rejected for government bodies by analogy with or using the principles identified principally in Woolwich as the reason why government has to give a remedy, are equally good reasons as to why change of position by government, arguing that we've changed position to our detriment, should not be a change of position defence. And similarly, it shouldn't be open to government on unlawful tax to argue no actual benefit. Now, these are big issues not to be done in 2 minutes at 3:20, but I didn't want them to be forgotten because...
Well, they don't arise at all, do they?
They shouldn't arise, but if my learned friend was allowed to argue...
You're not allowed to argue the European law point, are you? Are we not dealing, or are we, with European law in relation to compound interest?
I think only if the argument was you should say there's no actual benefit, the government conventional borrowing rate has been displaced or hadn't been made out, which is what I understood the argument to be yesterday. That is impermissible as a matter of EU law, having nothing to do with Littlewoods or anything like that. It's because you can't deny an interest recovery. And what I'm not seeking, and I said this very clearly in the written case, to suggest that we are running EU law is not being given effect to. In the light of your Lordship's judgments in Littlewoods, I don't seek to argue that here. But Lord, the other point...
We don't run EU law as an argument positively requiring compound interest. Yeah. Right?
So, Lord, if one then looks to the substance of issue 2, learned friend's case suggests that this court's being asked to recognise a new type of common law claim in unjust enrichment. That's not true at all. The unjust enrichment claim is recognised in Sempra, which was Hurst in the Court of Justice, and that is, and then was recognised by the House of Lords here as an English law claim in restitution based on the stake. And in Sempra, as your Lordships will know, the relief was given was compound interest for the period of prematurity. That was in the language of here, from payment of ACT on the basis it was paid by mistake, up until utilisation, the principal so-called sum of ACT having been repaid or treated as utilised effectively against lawful tax. Now, so you're not being asked, all you're being asked to do is to say, well, in the respect of category B, you're being asked to say, well, the logic of Sempra doesn't tell you that if there hadn't been utilisation, then the time value should be simple interest from the start under section 35A. And well, that simply cannot and does not make sense. If you have an unlawful ACT or ACT paid by mistake, and you're entitled to, for the period of prematurity until utilisation, compound interest, it makes sense to say if it's not utilised at all, say you're entitled to it back, but you only get simple interest from the start. Well, that cannot, in my respectful submission, be correct, because it invalidates the logic and principles of Sempra. And that we have set out in our case, but Lord, it doesn't take a huge amount of looking through Sempra to see that really the critical focus for Sempra is what Lord Walker described as the, I think he described it as the sort of central point of the judgments of Lord Hope and Lord Nichols, was that the interest to be recovered was part and parcel, or part of the sum to be recovered. It was not an ancillary claim for interest. Lord, I can take you a quickly look through Sempra, but we've set, first of all, Mr. Justice Henderson set out my argument in pretty much as I put it.
As you approve it.
As I approve at first instance. The Littlewoods Court of Appeal agreed with that, and the Prudential Court of Appeal has followed that. And indeed FII.
I think the argument against you is that Section 35A is an express statutory provision requiring A, discretion, and B, simple interest, applicable to cases where your claim of whatever kind is for the principal money. The submission, I think, is that Sempra was different because it concerned a case where the enrichment was temporary. Therefore, interest had to be claimed as a freestanding cause of action apart from Section 35A. But that when one is within Section 35A, there is not room for a parallel common law right to recover interest on a different basis and as of right instead of as discretion.
Well, that was argued in Sempra, that the interest...
Yes, but the reason why it failed is that the interest in that case was not being sought as an incident of a right to recover the principal. It was being sought separately on a freestanding cause of action.
But, my Lord, when one looks at the way that Lord Hope and Lord Nichols analyse it, the benefit that is passed to the revenue as an organ of government comprises two parts. It's the principal amount of the ACT and the opportunity time value, which is not being claimed. It doesn't matter whether you claim the principal sum with it or without it. The second part, the opportunity, the time value opportunity, is not ancillary interest for Section 35A. A restitutionary claim can fall within it, but this is exactly what was rejected by the judges in Sempra. All of the judges addressed that and said the fallacy of arguing Section 35A is to treat that as an ancillary interest claim within Section 35A. But just as it isn't within Sempra, so it isn't if you extend the period and have no utilisation and just recover the original. The benefit of time value has to be disgorged in full. And indeed, that's really, if one looks at Lord Hope and Lord Nichols and Lord Walker, and in fact, Lord Mance as well, albeit dissenting on burden of proof and so forth, the requirement is to return all the benefit of the time value with no partial giving back. That is the analysis in Sempra if one follows it through. And it doesn't, otherwise the logic would have said, Section 35A works for the period of prematurity. Just the fact that you haven't got to the end of prematurity, you've had the same benefit use value throughout the whole period of time, and the claim back must be the same, my respectful submission. And so far as the period after prematurity, which was Mr. Justice Park had decided against the claimants and said the period after prematurity.
What do you mean by prematurity? So just
after there was in Sempra, there was no issue that after utilisation, Section 35A
yes.
bit. That was decided by Mr. Justice Park and not appealed. But you'll see when you reread the judgments that both Lord Hope and Lord Walker and Lord Nichols, I think, two of them anyway, said we mustn't be taken as accepting that Section 35A bites after utilisation. And the reason for that, and it's important it's Lord Walker as well, the reason for that is that the logic and principle of the Sempra prematurity period up to utilisation applies equally after utilisation. It's still not an ancillary claim for interest. It's still part of the benefit which flows from the original enrichment by the mistaken payment of ACT. There's an argument that it was contrary to Westdeutsche, which you'll see is rejected. Westdeutsche, I don't need to go in, but when one reads Sempra, you can see Westdeutsche lacked the building bricks, apart from anything else, of it being decided by the House of Lords in Sempra that interest on damages could arise. And it wasn't argued at common law, it was only argued as an extension of equity. The other was it's suggested by my learned friend that this is contrary to BP and Hunt, the restitutionary claim. Well, that again was argued. You can see from the argument in note of argument in the report of Sempra that that was attempted to, but Mr. Justice Goff, as he then was, I think, wasn't addressing that point at all. He was just saying a claim for restitution can come within a claim for debt or damages, which Lord Sumption was referred to in Section 35A. But the critical point which we take from Sempra, and which has been approved going up through the Court of Appeal, is that we are not making that sort of claim for recovery which is bitten on by Section 35A. You don't get to 35A because that is part of the benefit. Lord,
does it follow effectively in all restitution claims, or almost all, where you're attempting to address the balance of an advantage, a financial advantage, which the defendant received, there should be compound interest?
It doesn't. That's why I think when it's referred to in Benedetti in the Supreme Court, it's expressed as being generally, or normally, I think is the word. The reason being is that in some cases, of course in government cases, we'd say it will become virtually invariable, either actually invariable, because government shouldn't be able to argue that it hasn't benefited in the normal and conventional government way, which is what the Court of Appeal in Littlewoods was getting at when it said the passage that was criticised by my friends. So you should at least be very dubious about anything where government says it hasn't used tax at least the benefit of the conventional rate.
I mean, my recollection of Benedetti is that there wasn't any issue there about compound interest. It was rather the point that I think Lord Clarke was making was to do with the use of the government borrowing rate being an example of what he termed subjective devaluation.
Yes, or I think he might have accepted that it was an objective valuation of the rate appropriate to the defendant's position. But to go back to Lord Mance's point, no, in private cases, all the classic cases about money not being used, being put under the bed and so on, you may get into the area where the burden of proof and proof of benefit can get into subjective devaluation of time value. You can't, I think, from Benedetti, subjectively devalue, if that's the right word. A disgorgement was disapproved, also the principal sum, but time value may be different for different people.
Do we know whether this is a common law principle or is it an equitable principle? And if it's the latter, is it a discretionary matter ultimately?
Well, my Lord, I would respectfully say it's a tricky question in the sense because in Sempra you've got two, Lord Nichols and Lord Hope, are cleared as a common law right with no discretion. And Lord Walker says, and if one looks at, I think it's interesting and important to look at what Mr. Justice Henderson said about this, because he analysed it. First, Lord Walker starts by saying he's essentially in agreement with those judgments, and he then works through.
He ends up putting it in equity, doesn't he?
He ends up saying he would prefer to put it in equity, but if one looks at what he is actually saying, where he says the central focus and the new light that's cast on the topic by the judgments of Lord Hope and Lord Nichols is there has to be a total giving back with no withholding. Now that doesn't suggest, if that's the central part with which he's agreeing, that does not suggest that he's saying that this should be dealt with in equity. He says he might have preferred to do it that way, but his approval of being essentially in agreement and his focus on the need for a giving back in full, and that's the insight that comes from Lord Hope and Lord Nichols.
And Lord Scott, at the best, is dicta, isn't he? Dictum on this, because he would decide the case on a different point, so it's a dictum.
It is, but on the other hand, if you're searching for numbers, Lord Scott does say specifically that he would have decided, if he'd had to decide it, which of course, given it then became the majority view that this was the outcome, he would have decided as a common law right. And your lordship was...
He didn't. So
he didn't.
I think the answer is there seems to be no firm ratio on that, but possibly a Lord Walker you can invoke to. One needs to study him closely.
Yes, but Lord, even if you look at your lordship's own judgment, you'll see that the incentive to full restitution is referred to in your own judgment. Whole giving back of the benefit. And of course, even if it becomes some form of discretionary matter, and your lordships were to think that contrary to my submission, as against government, there's no justification for a discretionary reduction of the objective government borrowing rate.
No, I was just wondering, and it is...
I can't invent some bit of the judgment.
We can't give you more time, I think.
No, Lord, I hope I've done
where it's covered by Mr. Justice Henderson, you say.
It is, and indeed, if we
Can you give
look...
the reference?
Yes, Mr. Justice Henderson's judgment.
We can find it.
Where he deals with it.
No.
The judgment is at 48-4, but I think your lordship's been looking at it in the 4 volume.
No, just give us a reference.
To the paragraphs.
Yes.
212 and following, I think.
Yes.
All right, thank you very much.
Yeah.
So, Lord, those are my submissions.
Thank you very much indeed. Yes. So you it.
My Lord, can I? I'm sorry. Can I make a slightly unorthodox request? Professor Burrows is very keen, very enthusiastic to address you for a couple of minutes on issue 2, which is the compound interest, with your leave, since we've only had 1 against 3 so far.
You're entitled to call for reinforcement.
Yes.
Well, thank you very much indeed for that. I'm just going to make some very quick points, if I may. The revenue's arguments in relation to compound interest are essentially of 2 kinds. One is the clash, which involves both categories B and C, and the other is a discrete point of principle on category C. There is also then a question, if you're not with us on those, how exactly are you interpreting Sempra Metals? But I just wanted to make a simple point on the clash argument, which I don't think has come out sufficiently clearly so far, and that's this, that in Sempra Metals there was no possibility of a clash with Section 35A because no statutory interest could have been awarded in Sempra Metals.
That's the point that I was putting to Mr.
And that is the point that Lord Sumption was just making. Why is that? And that is because there were no proceedings for a debt or damages to which interest could be added. The whole case was about trying to establish that there was a debt. So there's no possibility of a clash with Section 35A on Sempra Metals.
But are you saying that where there is a possibility of a clash, effectively there's a Johnson and Unisys point about Section 35A impliedly excluding any other method of obtaining interest?
Yes.
That
That's our essential argument
Yeah.
in the statement of case.
yes, is your argument. Yes, that's the clash argument.
Yeah.
Is there an answer to the oddity that is relied on against you, namely that it's very odd that you're much better off in terms of the interest rate you get if you've been repaid at some stage in the past, and if you haven't, on the face of it, you're worse off, but in terms of interest, you're not compensated for being worse off. You don't get compound interest, you get less interest.
All I would say at this point is that is the present position because of the application of the statute.
I see.
That's life.
It's the law. You cannot undermine a statute by developing the common law in that way. However one might think that the principle ought to be different, that is a matter for change brought about by the legislature in this particular instance.
But the argument is, surely, that you're not undermining it because you apply the Section 35A interest as a matter of discretion to the principal amount, and the principal amount in this case includes the interest, because the same argument which justified adding interest as a matter of right to the restitutionary claim that had been satisfied also means that it must be added to one that has not been satisfied, so that effectively Section 35A applies to the whole of the claim, including the interest as of right. Obviously, you don't double count, but subject to that, it's not, this is the argument, by Section 35.
I think we're going to, if I might come to the argument of principle why, I don't think there's an unjust enrichment, or we argue that there's no unjust enrichment claim in any event in Category C, one might see that it's not as straightforward as you've just indicated. So can I just very briefly address you in relation to what I think is a very important argument of principle for the law of unjust enrichment. So standing back from the detail, what is being argued in relation to Category C is that this turns on what is meant by at the expense of the claimant in the law of unjust enrichment. And it's become clear after the investment trust company's case that the concept of at the expense of is performing a very important role in keeping the law of unjust enrichment within acceptable limits. And what effectively a very wide view of at the expense of might lead you to think is that you just need some sort of but-for causal link between a loss to the claimant and a gain to the defendant. And what the investment trust company's case derived through other authorities to reach it has said, albeit in a three-party situation, is that that would be too wide. One must have a narrower concept of at the expense of, which was articulated as a transfer of value from the claimant to the defendant. Now, if we turn to Sempra Metals and apply that approach in the context of interest, what Sempra Metals was saying was that apart from the transfer of the tax payment, there is also the transfer from the claimant to the defendant of the opportunity to use that tax payment. And clearly when that tax payment is repaid or is offset by against lawful mainstream corporation tax, the opportunity to use that tax payment ends at that point. So that clearly while the claimant is entitled to restitution of unjust enrichment to interest, let's assume we've had a tax payment of £1,000, you can have interest on the £1,000 until it's been repaid or offset. That's the opportunity that's been transferred. You can't have interest on top of the interest because that has not been transferred. There's no transfer of value from the claimant to the defendant as regards that. Now, it's true that the defendant may gain, so the revenue may gain by not having repaid the interest on the £1,000 tax payment. But that gain hasn't been transferred by the claimant to the defendant. It's not at the expense of the claimant in the relevant sense.
What about my analogy of the loan of the car? For a week,
yeah.
Implicitly, what you're transferring actually is really the use of the car. Why,
Yeah.
if you give money to someone for a week, aren't you transferring?
So when the car comes back, you're entitled to the use value of that car, but it's now come back. You cannot have interest on top of the use value because it stopped at the point at which the car's been paid back. Now, what the test claimants are wanting here is interest on the use value.
Yes, I see.
And that has not been transferred from the claimant. All it is that you are continuing to gain by not having paid off the debt of interest. So it's like any other debt claim. So I'm a claimant, or I'm a creditor, and you're a debtor, and I, for some reason, mistakenly fail to enforce my contractual debt against you. Nobody would suggest there's an unjust enrichment claim by the defendant having gained by not having repaid the debt on time, even if we can find this an unjust factor-like mistake. And that is why, as a matter of principle, the Category C claim has to fail under unjust enrichment. That's why all that can be claimed is simple interest. And as for this not being permissible for us to actually raise, you'll see that, as Lord Mance pointed out, Declaration 10 leaves this completely open. We are saying simple interest only under Section 35A.
I think they'll accept you're entitled to argue that. It's all these other change of position defences.
Yeah. Fine. So that's your answer to Category C, and your answer to Category B, which is unutilised ACT, is Section 35A.
Yes, and if you're against us on Category C, of course, the same argument of clash would apply to both B and C. Yeah. I'm going to sit down at this point to let the leader carry on. Thank you.
Thank you much.
Thank you, my lord. Yes, my son lost his voice last week, and I was sure this was going to happen this week. So I think I'll just get through half of it. 20 minutes.
20 minutes. We wish you luck.
We go back to what Mr. Aronson was saying about FII ECJ 2. Can I just make one very brief point about the history? I think Mr. Aronson probably made this clear. The questions about foreign nominal rates was not part of the test claimant's case, and it wasn't addressed in the written observations apart from the Commission who raised it, I think for the first time in their written observations. And there was, of course, some discussion of it at the oral hearing, which is, as your lordships will know, is very, very short. And there were a lot of other issues that had to be determined.
But you would
So-
agree that it's helpful to look at what the Commission said, in fact, to see how it came up.
Yes, yes. But what it also tells you is, it's not as if this point was argued out between the parties in written submissions and whatever. It came out of the court, and you'll see it was a surprise. It didn't come out of the Advocate General's opinion. It came out of the court. So it hasn't had the kind of consideration that a point like that would have if it was dealt with in the English courts, obviously. But what is clear from ECJ2 is that the rationale for their decision on foreign nominal rates is that you have to top up the effective rate of tax paid by the foreign subsidiary to the nominal rate so as to reinstate, in effect, reliefs which the subsidiary has received. And that's what the court said in paragraph 48 of the decision in ECJ2. They say it expressly. This is .2807, MS 2807, the bottom of the page. They're making the point that under the exemption system, in effect, the benefit of the reliefs enjoyed by the subsidiary are retained because the parent isn't taxed any further.
Sorry,
but under the imputation system,
28.
it's MS 2807.
No, I'll find it in a minute. Yes,
It's in Authorities Volume 8.
yes, I thank you very much. Yeah,
It's behind tab 73.
yeah, no, I've got it.
And I think it's common. That's the underlying rationale for all of this. In the domestic situation where there's an exemption, you still get the benefit of them. In the foreign situation, you lose it if you use an imputation system. And the reason, therefore, for using the FNR is to top up the effective rate paid by the subsidiary. And that's why the whole that's why we say, and Mr. Justice Henderson agreed in FII, that the rationale behind the decision of the ECJ in this case was that you have to look at the company which actually bore the tax. And you're topping up that company's effective rate of tax to the nominal rate. My learned friend cited paragraph 61 as supporting the contention that you simply look at the Water's Edge company. In my submission, that paragraph doesn't support that, and you have to then read you have to read on to paragraph 62, which makes it absolutely clear what the court is talking about. It's talking about the nominal rate of tax to which the profits underlying the dividends paid have been subject. And I've already made the point about Haribo and the fact that the simplified method that they're referring to there, although it uses the foreign nominal rate, it uses a foreign nominal rate which the taxpayer has to demonstrate was actually applied. So the taxpayer not only had to show what the foreign nominal rate was, they had to show it was actually applied to the profits, that there wasn't an exemption or whatever which applied. So it isn't a justification for just using the Water's Edge rate. My learned friend says that the reason for distinguishing, having different approaches to FII and portfolio dividends is because of the nature of portfolio dividends. They're very small investments. So he's sort of, in a sense, turning the argument that they should be treated the same on its head and saying they should actually be treated differently. But what he doesn't address is why you cut the line at 10%, which is portfolio dividends. Surely a company which had a 15% shareholding would have a similar problem, potentially. But it seems that they would be on the wrong side of the line, and so they would have to prove the tax, the foreign nominal rate, down the chain. As regards what was argued at trial, it was never agreed no one's ever said it was never agreed by the parties that the correct foreign nominal rate to use was a water's edge rate. The revenue's position there was quite different. The revenue's position was that you had to look at the actual tax paid, which clearly wasn't looking at the water's edge company. It was looking wherever the tax was paid, possibly down the chain. So there wasn't any common ground on that at trial. And this is an issue that was decided, I would submit, by the judge as a matter of principle. And if he didn't decide it as a matter of principle, then he was wrong, because the correct foreign nominal rate to apply cannot depend upon the difficulties which the taxpayer has in proving his case, which is essentially what I think is being suggested. And that is actually where Haribo comes in, and the part of the judgment which I showed you, the answer to question 4, if you remember, which showed that it is an intrinsic part of the imputation system that the taxpayer has to prove what credit he's entitled to. And if that's proving tax, he has to prove what tax was paid. If that was proving FNR, he has to prove that.
What do you say to the point that there's one thing when you've got a law or a practice which clearly tells you what you've got to prove, quite another when that's imposed retrospectively some years later by a decision of the ECJ?
My submission is that question 4 was about the latter situation. Question 4 was, in fact, about the latter situation. If you read question 4 carefully, you will see that they were talking about situations in which, under Austrian law, no credit was available at all. And what happened was that the administrative court in Austria decided that that they shouldn't apply an exemption, but a more appropriate method would be to give credit for tax paid. And as a result of that, the Austrian authority, national authorities, applied that. So it's a case where the law as it stood at the time was you didn't get any credit at all. But a subsequent court decision led to the national authorities granting credit for tax paid.
Well, the practice note that you referred us to, MS 2443, did that follow the administrative court decision then, or?
No, I think that preceded it. That's not exactly what I'm talking about. What I'm talking about is if you have to read again question 4 and the answer. But if you read through it, you will see that what the court is saying is that. Sorry.
You're talking about the underlying liability, whereas the 2008 note is just concerned with the practicality of
Exactly, my lord. But the problem that arose was even when it had been decided by the administrative court that you were entitled to imputation credit, it was still difficult, if not impossible, for the claimants to demonstrate that, and that was what they were complaining about, and that's what question 4 was about. You'll see that if you read through it.
Well, I'll look at it again, obviously.
Yeah.
So you might have to default to the nominal rate for want of any information that the effective rate was any different.
Well, an interesting point is, in Haribo, despite the fact that the Advocate General did point out, you've seen, my learned friend showed you, that there was a disparity between the effective rate and the nominal rate in Austria. The court didn't suggest that you defaulted to the nominal rate, except if you did it under the administrative practice, if that's what your lordship is referring to.
Can I just ask one thing on, have we got to the question whether you're entitled to look at the feeder companies, the companies actually making the relevant profits, as opposed to the Water's Edge company distributing the dividend?
Yeah.
Have you covered that effectively?
Well, what I've said is it was suggested that the trial was run on the basis that there was an agreement.
Yes, I thought
that it would be that it would be the top Water's Edge rate. And
yes,
I've said there wasn't an agreement to that effect.
Sorry.
Yeah, there wasn't an agreement to that effect.
No, it goes a bit further. There wasn't an agreement to that effect, but you then did apply to the Court of Appeal for permission to erase that point in the Court of Appeal, and at 3502, am I not right that you appear to have been fairly and squarely bowled out, permission refused on that?
Well, I think the way it seemed to have gone is we were granted permission by the judge to appeal against that under the judge's order.
I was just going to suggest that it would help me enormously if, there are a number of points that said you're knocked out because you didn't get permission even to appeal to the Court of Appeal, and we've been referred to various orders. And although one could dig around in your answer, it would be very helpful to have on one sheet of paper, or 2 sheets of paper, what your answer is to where it said you're simply bowled out
Yeah.
by the decisions of the High Court or Court of Appeal.
We can do that.
Are you able now, without limiting what you're going to do for Lord Carmouth and for all of us, to give us the judge's order, which you say did give you permission? Because there seem to be 3 judges' orders in the appendix
I
part
thought
1.
it'd be better to let him do it.
Yes.
All right, we'll do it.
It's the
10
main
minutes to
the
come.
main order that the judge made following the main trial.
Yep, do it later then. Do it later.
We'll give it in writing. It's probably the
Yeah,
best.
thank you.
I can deal then. I have to deal then, I think, with issues 5 and 3. Issue 5. Now, the question we say that arises in issue 5, the underlying question is, how was the defendant enriched by the claimant's mistake? And the claimant's mistake, which was alleged, is that it was mistaken because it paid tax for which there was in fact no liability to pay tax. And you can see that. It's quite useful, I think, to turn up Mr. Justice Henderson's judgment, paragraphs 163 and 164, which I've taken you to already, which sets out the basis of this. And paragraph 163C,
Page?
sorry, it's paragraph 163, it's page 3648, MS 3648.
All right.
C says that revenue don't dispute that the tax was in fact paid under an operative mistake, the mistake being that it was lawfully, the mistake being that it was lawfully due and payable when it wasn't in fact lawfully due and payable. So that's the basis of the claims in mistake. And then you can see in 164, this is how it was agreed, I think, between the parties that unlawful ACT would be dealt with. When it was utilised against lawful tax, it was recoverable on the Hurst basis. Now, this is all on the assumption that there was a payment of ACT. We don't say that the ACT payment was a nullity. My learned friend suggested we said everything was a nullity. We don't say that. There was a payment of ACT. It was in response to a charge that was unlawful, but there was a payment of ACT, and it was then set off properly under section 239(1) against a lawful liability to corporation tax. And that occurred, and that results in a Sempra or Hurst type claim for the time value of the money. That's because there was an ACT payment. As I say, we don't say it's a nullity. And we don't say also...
It's an unlawful ACT payment.
It was an unlawful charge, but there was an ACT payment. It
Right.
wasn't a nullity, there was an ACT payment, which was then set off.
set off something which is due. Anyway,
Yeah.
you say it's set off under section 231.
Well, it was paid. It was paid, and it was then set off. There was also, although there was an unlawful charge, where corporation tax was paid, there was a payment of corporation tax. There's no doubt about that. Where we take issue, and this is relevant to issue 5, and issue 3, is that we say that because there was no liability to corporation tax, there could be no set-off under section 239(1), where lawful ACT was thought to be set off against unlawful corporation tax. That didn't happen. And that's the basis also of what Mr. Justice Henderson says in paragraph 164B, which has been common ground in all these cases and has been the basis in which the restitution has been computed, that unlawful ACT, which was utilised against unlawful MCT, is recoverable on the basis that the purported charge, that is a charge to corporation tax, was a nullity. In other words, there was no liability to corporation tax, which is exactly the point I think my Lord Mance was making to my learned friend Mr Bremner that there was no liability and therefore section 239 simply didn't apply. So unlawful ACT has always been regarded as recoverable, even when it was purported to be set against unlawful corporation tax. So we don't say there's any nullity. We've never taken the approach, which my learned friend seems to be putting forward, of stripping out unlawful tax in some way. And I am extremely concerned that an approach like that would lead to a fundamental change in the way that all of the restitution has been computed. Because that is not the way that this has been dealt with up until now.
What, stripping out?
Stripping it out, yes.
As per tables A to D.
It hasn't been. We haven't been taking the approach of just stripping out unlawful tax and somehow ignoring it, and then applying the UK system.
So what approach happened?
We've assumed that the UK system applied to, for instance, unlawfully charged. Applied where there was a charge, an unlawful charge to ACT. We've assumed that it could be set off under the UK system, and it was set off. That's exactly why you have SEMPRA-type claims. The only basis of a SEMPRA-type claim is that there was actually a set-off against a lawful liability to corporation tax. So it's always been assumed, and I think correctly, that these things happened. But that doesn't affect the point that where you had a lawful ACT that you purported that was set off against unlawful corporation tax, there was no liability to tax, and so Section 2391 didn't apply at that point.
And can you remind me what exactly you mean when you talk about unlawful ACT as distinguished from lawful?
I'm referring to tax that, having applied the other principles, it has been determined that part of the ACT was charged unlawfully. It basically means that there was foreign income, EU dividends, let's say, which were redistributed. And when these foreign dividends are redistributed, it is only lawful to charge ACT up into the value that you could charge MCT. Remember, that's paragraph 72 of the judgment. So what happens is a determination is made, looking at each payment of ACT and determining whether on those principles there was an unlawful charge and to what extent there was. And then once you've done that, you then decide what happened to that ACT. So there is plenty of lawful ACT as a lawyer was suggesting. For instance, if there was a redistribution of UK domestic income, there would be a perfectly lawful charge to ACT on that. There couldn't be any objection by the EU to the UK charging ACT when UK income was redistributed by a company.
You were tying this to quarters, so that you could only lawfully charge. The statute requires ACT to be paid on distributions made during the quarter.
Yes.
And are you saying it's only lawful to do that under EU law to the extent that the distributable profits, the profits available for distribution during the quarter are subject to MCT, to lawful MCT?
In principle, it's only lawful to charge ACT up to the amount to which it would be lawful to charge MCT in respect to the dividend. Now, the way that's been put into effect in UK law by conforming interpretation is to apply some kind of credit to achieve that. Yeah. But I'm looking at the principle. So you look at each dividend that's paid by the UK company and you decide whether part of that, the ACT which it was charged and paid, was lawful or unlawful. And you do that exercise and then you decide how it was dealt with, when it was set off, if it was set off at all, and how and when it was set off, because you need to determine that to work out the amount of restitution, because you get a different answer if it's set off and if it's not set off, and when it's set off makes a difference because you have to apply rates of interest.
Is there I mean, that's very interesting the way you put it.
Yeah.
Is there somewhere in the papers which sets that out clearly, either in the judgment or your...
Probably Mr. Justice Henderson's
Usually
judgment.
it's Justice Henderson somewhere.
Yeah, yes.
If you could let us know.
If I could add that in, I'll try and find something that says it out. But
No, it's enormously
I think
useful
that's
to have in writing
yeah,
a view of things which you now accept as the correct view.
yes. That's the basic way. So we've decided that certain amounts of ACT are lawful and some are unlawful, which is why there was common ground in the agreement and the statement of facts and issues. We were able to agree the effect of issue 3, because we know that there was a certain amount of lawful ACT that was set against unlawful ACT under the methodologies that we've been applying. And the only question then is, does that result in a claim? Just dealing with that, I'm sorry, I'm running over time, but can I deal briefly with that? Our primary case there is you're only entitled, there was no set-off. I think as has been discussed, the ACT remained outstanding. And the result of that is either it would be dealt with under the statutory procedure in relation to years from 1994 where they're all open. Now, if Prudential can establish that ACT would have been used because it was carried forward in a subsequent year, then they'll be able to reduce their corporation tax liability for that year, and it will work through
So isn't there a slight
in the statutory procedure.
inconsistency between your approach at this point? There's no set off, the ACT remains outstanding, and your resistance to the stripping out approach, which seems to, on the face of it, rather similar to the approach you take that the ACT remains outstanding, not when it's set against unlawful
That was
corporation tax. I mean,
that's lawful ACT remained outstanding.
lawful ACT.
That's lawful ACT.
Yes.
I mean,
Well, one would have thought there might be a stronger case for just disregarding as ineffective the unlawful elements of some transaction where both sides are unlawful. Transaction, there is ACT and corporation.
yes, but it doesn't work that way, my lord. It isn't the same transaction where there's lawful and unlawful ACT. The lawful ACT might be being carried forward from a previous year. The unlawful ACT might be being carried forward from a previous year. There's no necessary connection.
No, but they're still invalid. They ought to be there, is the argument, and the simplest way to rectify the situation is just to ignore them.
Well, I'm not quite sure what that means
Except
exactly.
for payments. The payments made
Yes.
under them are obviously got to be corrected.
Well, the trouble with just ignoring them, if you say, well, every unlawful charge to ACT must be repaid in full, then you ignore the fact that some of that, we know that because that's a lot of the claims, some of that was actually set off against lawful corporation tax. Yeah. And you must be able to determine when that happened and if it happened. Otherwise, the claims will be magnified enormously.
Right. No.
So it's not simple as just taking out all the unlawful tax and saying you get it all back.
No, well, you obviously got to take them out and see what would have happened or should have happened without them. That's the argument against you.
Well, but my argument would be that's not what you do. What you do is you see what did happen to them, because we're responding to claims here in unjust enrichment, claims that say in a particular time we were not liable to pay tax, and we paid it by mistake, and therefore we went to get it back.
I think I'd like to have a better.
That's why I started with saying.
You said it would be a disaster if, or
not a disaster,
radical change if you adopted the approach taken by the other side. Is it possible again to just explain that? Not necessarily now, but I think we're going to invite some further short document to be submitted.
I'm sure I could, but it may depend on exactly what I understand the claimant to be saying. But, I may have to, but it sounded to me like a very new idea that you simply strip out all the unlawful tax.
It's in their case.
Yes.
It's in their case. Right.
Yeah. And sorry, can I just finish?
Are you going as far as saying that submission is inconsistent with the way the matter was agreed in paragraph 164?
Yes, I do.
You are going that far?
I do. I say the only basis on which you could have 164B is that there is no set-off. And that's also inconsistent with the way that the claimants, test claimants say that things operate under issue 5. Because they end up by saying that the unlawful ACT in that example is set off against the unlawful corporation tax, and they have a time value claim, which is why I found their whole computations on issue 5 quite puzzling, because they seem to be contrary to the way that we've been carrying out the computations, carrying out the exercise of restitution up till now.
Right. So is that...
Yes. I must just deal with all the new cases on issue 3 that have been put forward. I tried to make it clear that we've been responding in this case, in this trial and appeals, to a simple case, which is lawful ACT against unlawful CT, you get it back automatically. It's a completely different case to say there was a knock-on effect, which had an effect in another year, which has a consequence. We would say all of that would have to be set out, pleaded, evidence put forward and tested, and we haven't got any of that. We don't accept what they say in the note about them having a massive capacity for setting off ACT.
This note?
Yes, we don't
I would
accept.
certainly welcome subject to.
We've only looked at it obviously today. We only had it today,
So
but
are you going to put in a response to that?
well, I suppose the first question is how detailed a response do we require? Because our fundamental point is these issues just don't arise on the case as it's currently been put. They're putting forward evidential points that weren't explored at trial.
There's been talk of a speaking note of yours, which
I think that's a reply.
I think they were referring to, we put in a reply to the cross appeal.
I don't think is there a spare copy of that. I don't see.
Yeah.
Thank you.
This was simply because,
I don't mind why it was done.
yeah, the procedure
I've
seems
got
to
it.
be that they put in their cross appeals at the same time as their responses, so we had to reply to them. But our fundamental point is that to deal with this kind of argument would require a reopening of the trial, effectively. We do have, if your lordship so like it, copies of the white paper that was mentioned yesterday, of corporation tax.
Well, if it's helpful.
If you'd be interested, I think you requested, you might want to.
Yes,
look at it.
well,
So,
we certainly have it.
we also have, Ms. Pobrano has annotated the chronology with references, if that would also be helpful.
That would be very helpful.
Yeah,
Yes.
I liked that a few days ago.
I'm sorry about that one. It's the same chronology, it's just got the references to the bundle.
Can you help me on one point on the tables which appear in the respondent's note? You take issue with them on 2 points, but the first point I'm not sure I understand or accept. You say that the only MCT paid was the balancing payment, but I mean that overlooks the fact that it isn't a balancing payment, it's a top-up payment, and ACT has been paid by reference to the foreign dividend income, which has not received any credit relief. So surely one has to add to the balancing payment the ACT, the proportion of ACT which related to the foreign dividend payment and was paid because there wasn't any credit in respect to the foreign dividend income. So you add that.
I'm sorry, my lord, you talk about the balancing payment. You mean
Well, I think
unlawfully charged ACT, is it, essentially?
You've said in your notes that the total amount of MCT paid was £18.75.
Oh, I see.
Of which £12.50 was charged lawfully. That means that HMRC were unjustly enriched by the amount of £6.25. That's just looking at the amount of your unjust enrichment as a result of receipt of the balancing payment of £18.75. Surely you've also got to take into account any unjust enrichment by reference to your receipt of the ACT.
Oh, yes, that would be dealt with separately, yes.
Oh, I
That
see.
was
No,
unlawfully
well,
charged.
I thought you were pointing out a fallacy in their argument, but I mean, it seems to me you're on common ground then, because the total unjust enrichment must, on the face of it, be £25.
I'm not.
Which was the tax on the foreign dividend, sorry, which was the ACT on the foreign dividend, I think.
Yes.
Yes.
Well,
Corporation tax on foreign dividend.
The corporation tax on the foreign dividend, the total corporation tax on the foreign dividend, including ACT.
well, some of it would, I think, I have to remind myself of the example, some of it would have been dealt with by lawful ACT. So it's by lawful ACT, I think.
Yes, I see. Well, that's your prorating point, is it?
Yes.
Yeah.
Yeah.
Right. Well, that is it.
I think those are our submissions. What would you like us to
Well, I think
put in writing?
how much time do you require? If you could do something by within a week, at the end of Thursday next week.
Certainly.
Obviously, both of you have a chance, and short, and just covering the points which we've raised rather disparately.
Yes.
Quite a lot of them recently, but they'll appear from the transcript.
Yeah.
And I appreciate your difficulty about the detailed points on the, but if that's up to you how far you want to go into them.
Yeah.
Are you happy with that?
Not really with the intricacies of issues 3 and 5, but issues as whether there's permission to appeal, etc.
Yes, that was coming from your side in
Yes.
response. Yes. And if you do need, I mean, I hope you won't need longer than effectively next Thursday. But obviously, if you do, you can apply. The court's very grateful to counsel on both sides and those who helped prepare what is a complicated case on any showing. The court will take time to consider its judgment.